Caroline Foote. I'm an advisor at the Tenant Farmers Association. Going to talk today about not only the importance of having a written agreement, but also understanding it. I often speak to members who might have had a verbal agreement, perhaps for several years, on a gentleman's handshake or something like that, which is usually fine, essentially, until it isn't. I just want to stress the importance of having that written agreement in place, clearly setting out everyone's rights and responsibilities and anything else that's been agreed, just to avoid that dispute down the line and just make any disagreements slightly more easy. However, it is equally troublesome, we find, if there is that written agreement in place, but it's not been understood. I think in some cases, tenants are just happy to have been presented with an agreement with rentable land being so scarce, they don't necessarily question what's been put in front of them before they sign it. In other cases, I think perhaps the tenants don't understand all the legal jargon that's in the agreement, which is perfectly reasonable. You're farmers, not lawyers, but it just stresses the importance of perhaps seeking professional advice before you sign that agreement. Because once it is signed, it is a legally binding document, so it's just important to seek that advice before you get to that stage. Landlords and tenants obviously rarely want to fall out, and it would be sad to think that you're going into an agreement anticipating a fallout, but the written agreement just provides that safety net in case anything's unclear or forgotten in the future, and just makes any disagreements much more easy to resolve. So on that basis, it's quite important that those agreements that are put in place are quite comprehensive. All the details of the letting that's been agreed, so the rent, the length of the term, etc., repairing obligations, for example, setting out everyone's rights and responsibilities so that everyone's clear. And also a dispute resolution procedure is quite sensible to have, so either arbitration, for example, or an independent expert. Just something so that if the agreement doesn't cover it, or there's something, as I say, not covered in the agreement, then you've got a route to resolve that as well. So not only the initial sort of agreement that needs to be written up, but any changes throughout as well. Any permissions that have been granted by the landlord, for example, for some diversification or some subletting, it's just as important to have those agreed in writing, kept to the original agreement, again, to avoid dispute and disagreement down the line. The other thing that's important is to make sure that you have the right type of agreement in place. So whether that's a tenancy agreement, a grazing licence, contract farming agreement, for example. There's many more agreements that could be suitable. Landlords might have their own preference on what type of agreement. It might be for personal reasons or for tax reasons particularly, which is fine, as long as what's happening in reality matches what's in the agreement. It makes those agreements meaningless if they don't match what's happening in reality. We've got a useful guidance note on the TFA website about things to look out for in a new agreement. Also, TFA advisors are on hand to check through any new agreements you might have, see if there's anything you need to seek further clarification on or you might want to negotiate on, and just to give you that peace of mind before you sign that agreement. We can also advise on the type of agreement that might be suitable in your circumstances. So if you are thinking of signing a new agreement, do get in touch.